Everyone. Good afternoon, students. My name is Mahima Dugal. I am your CUET PG faculty for the mission JNU Batch 2027, and we welcome you to this course with the hope that we are going to complete it with all flying colors. So as the beginning of this particular session, I want to introduce you to a very interesting topic. We will begin with the first topic that I have selected, fundamental rights, from the major unit of Indian governance and politics. So before we begin this particular lecture, I would first ask a simple question from all of you. For example, say tomorrow the government announces, the state announces a law saying that you and I, everybody, men, women, are not supposed to wear clothes in which your sleeves, your arms and your legs are visible. So basically, the government imposes a dress code on all of us and gives some cultural or social reasons for it. So will that be okay with all of you? Now, technically, the state has made a law using its branch of legislature. So technically, everything is correct. I don't think technically there is any problem. The majority has voted for the bill, and the bill has now become a law. And now we are all supposed to follow uniform dress code from tomorrow onwards. So will we be okay with it? I'm assuming most of you would say that no, we have the right to wear what we want. We have the right to choose what we want and how to look and how to carry ourselves. So when we say the word right, we have the right, what do we mean? If the government is following all the technical steps and is absolutely doing the right thing, is going by the textbook, then why cannot government make certain laws? Why cannot the government stop us from doing certain things? Where do we draw this boundary? Where do we decide how much is too much for the government to decide for all of us? So that line is decided by the fundamental rights enshrined in our constitution. So the very introduction to fundamental right itself tells us that how important it is, because the fight for fundamental rights began much before independence. Right in general is a claim that we as individuals make on the state and on each other. That means that our right is to be protected by the state. And because this particular contract becomes regularized and normalized, fundamental rights were put by our constitution makers in the constitution itself, so that irrespective of the governments that come and go, it makes no difference to the basic rights that all of us have. They are called fundamental rights for two reasons. One, that they're protected by the fundamental law of the land, that is the constitution itself. And the second is that they're very, very fundamental to the development of all the human beings. They're foundational for the development, for the fostering of creativity, for our well-being. So for the first time before independence, it was 1928 when fundamental rights were first introduced as a concept formally before the British government by the Motilal Nehru Committee. And I would request you all to pay attention to all the parts that are highlighted in the PPT, because as much as our understanding of a topic is important, we have to also understand that this particular exam is an MCQ based exam. So all the factual information is also equally important. Although if I really promise you that if you understand each and every part conceptually, with time, with regular practice, you won't have to cram up anything. By the end of the course, you will learn all these facts, but do pay attention to all the highlighted details. So Motilal Nehru Committee is one such important committee. And finally, when we got independence and the constitution was made by our own constitution makers who were elected by the people of India, they enshrined fundamental rights in part 3 of the constitution under article 12 to 35. Each of the article will be discussed in the class later. Now, this particular feature, fundamental right, has been taken from the USA's constitution. USA has something called Bill of Rights. We have taken it up as fundamental rights. The fundamental rights are guaranteed and protected by the Constitution. Constitution is the law of the land. That means that the government is also not above the Constitution. The government also runs remaining within the boundary of the Constitution. Originally, the Constitution had 7 fundamental rights. But over the years, one fundamental right was dropped. That was the right to property by the 44th Amendment Act of 1978. And now the right to property is still in Constitution. It is a legal right. It's part of the Constitution, but it doesn't fall under the fundamental rights. That means its nature has been slightly diluted now, and its protection is not as strong as all the fundamental rights. So it's in part, it's in Article 300A in Part 12 of our Constitution. Now, before we begin discussing our fundamental rights in detail, we need to know certain features of fundamental rights. So some rights are for the citizens only, while the others are for all the people. What does this mean? Now, when we say fundamental rights, it's a huge responsibility on the government. It's a huge claim that we as citizens are making on our government, that the government has to protect. Now, we as citizens are protected by the government, but there are certain rights which cannot be given to the aliens or foreigners who don't belong to this land. And there may be some reasons, for example, security. For example, there are certain countries which Indian government declares as the enemy nations. Maybe the country is at war with them. For example, when we were at war with China or we were at war with Pakistan years back, maybe at that particular point of time, we could not give their citizens the fundamental rights that our citizens have. Because at that point of time, it's an enemy nation. Any citizen of that particular country could be a threat to our national security. So all the fundamental rights cannot be given to the foreigners. One thing we have to remember, fundamental rights are extremely important. The Constitution has made all the provisions to protect them, but still, they are not absolute, they are qualified. This means that the state can impose reasonable restrictions. For example, all of us have right to speech, but that does not mean that we can say anything and everything without considering the rights of other people. For example, you cannot badmouth somebody else's religion. You cannot defame somebody without a reason. That would be an offense. So your rights are always qualified and not absolute. Some restrictions are there. The third feature is that all of them are available against the arbitrary action of the state. That means that these particular fundamental rights are enshrined so that the state knows its limits and does not cross those limits and arbitrarily violates the rights of the citizens, the space of the citizens. So all these rights are available against the arbitrary actions of the state. Some of them are negative in character and place limitation on the authority of the state. For example, the right to form unions. So the right to form unions, it could be student unions or labor unions, is enshrined in the Constitution. Now, what are unions formed for? We all know that unions are formed for bargaining. The students bargain, the labor unions bargain with the government for their rights, for better pays, for better working conditions. Now, these particular rights cannot be, now, although state would not appreciate it, because these are negative rights. This particular right to form an association, to form a union, imposes certain restrictions on states. State would like to stop such formations because they create hindrances. They might create hindrances in the working of the state. But the state cannot do so because every citizen has the right to vent out what they want, what their demands are from the state. So these rights, they place some limitation on the state's ability to stop us from doing certain things. So they are negative also in certain characters. They are justiciable, and individuals can approach the court if their rights are violated. That means that rights are just not a fancy word. If they are violated, if the state violates your rights, you have the right to file a writ petition in the court, and you can directly approach the Supreme Court. We have a hierarchy in judiciary. There's a district court, there's a high court, there's a Supreme Court. Usually in every case, we have to follow that hierarchy. In case of fundamental rights, the hierarchy can be broken. You can directly approach the highest court of the land. They are defended and guaranteed by Supreme Court. They are not sacrosanct or permanent. The Parliament can amend or repeal them, but only through a constitutional amendment and not by ordinary laws. So in another chapter, we will discuss how our constitution is amended. But for now, it's important for you to know that certain amendments are easy to make and certain amendments are difficult. For certain amendments, the government just needs a simple majority. For certain amendments, like fundamental rights are very important. So if government wants to change them, wants to reduce their scope, wants to delete them, for that case, it can be done. But it's a tedious job. The government will have to go above and beyond to collect special majority to do that. So in that case, they are not that easy to amend. Their application to the members of armed forces, paramilitary forces, police forces, intelligence agencies, and other analogous services can be restricted or abrogated by the Parliament. So the fundamental right itself has a provision under Article 33 that says that certain citizens will also not get fundamental rights, and certain citizens, the category is mentioned on the slide from 1 to 0.5. So for example, now, say, for example, India is at war with some other country, or some soldiers are at this particular point, as you and I are sitting here, some soldiers are still stationed at Siachen or some very difficult terrains. Now, in those terrains, of course, they don't have all the fundamental rights. Their right to life is being violated. They're sitting at minus 50 degrees. Their health is being affected. They're away from their family. Their postings are so difficult, they probably can't meet their families for very long. Now, in normal circumstances, if the government imposes such conditions on normal people, they can file writ petitions saying that this is against their fundamental right to life. But if such freedoms are given to the armed forces, then it would be a national threat to the nation. Then it would be very difficult for the government to manage the security. So that is why certain rights, fundamental rights, are not applicable to the armed forces. Their application can also be restricted while the martial law is in force in the area. Martial law is, I'm assuming you all know it, but I'll briefly give a description. Martial law is when the general administration is not functioning and there's a breakdown of the general administration. The civil government is not able to function. The military is called in. The military takes over, and at that particular point of time, the military doesn't rule according to the laws of the land. They have their own set of laws. They have their own set of policies that they rule. And once the peace is restored, then they give back the administration in the hand of the civil government. So during that period where the military is taking the charge of our government, of our working of the entire civil organization and machinery, that is known as the martial law. So during martial laws, these fundamental rights, they do not exist because it's an extraordinary circumstance. Most of the rights are directly enforceable, while a few requires that the laws are made by the parliament or the state legislature. For example, the right to life itself is very self-explanatory, and if your right to life is violated, you can directly approach the Supreme Court. For certain laws like child labor, we need to exactly define what child labor is. Who do we consider a child? Somebody below 14, above 14. If we want to reduce the age, increase the age, in that case, certain laws have to be passed in supplement of these rights. So these are the basic features of fundamental rights. I hope they're clear. If there's any particular doubt that you have, we're here to resolve. Okay, let's move on to the specific provisions, the articles and the provisions of fundamental rights. Each provision can be discussed in a lot of detail with a lot of examples. But since we'll be keeping this class a bit short, it's just an introductory class for fundamental rights. So I'll keep it very short and crisp, and we can take up the details in the next class maybe. So from Article 14 to 18, we have all the right to equality. Article 14 states that equality before law or the equal protection of law. That means that if two people coming from two different socio-economic backgrounds, commit the same crime, they would be treated at the same pedestal when they would be standing in the court of law, and the punishment was being assigned to them. So everybody is equal in the eyes of law, does not matter which class or which caste you belong to. Article 15 states non-discrimination against any citizens on the grounds only of religion, race, caste, sex, place of birth, or any of them. That means that you cannot be discriminated on the basis of any of the mentioned criterias. Okay? Your entry to a particular place cannot be stopped. For example, a public park is a public park, and everybody who's a citizen of this country and everybody who's a resident of that area can visit that park. And your religion cannot stop you from visiting. Your race cannot stop you from visiting. Article 16 says equality of opportunity in the matters of public employment. Now, this means that every job, every vacancy that comes up in the government sector is equal to everyone. Everyone has the right to equal opportunity in matters of public employment. There is no particular bias for any job for candidates coming from a particular community. Then we have Article 17 as abolition of untouchability. Untouchability was a social condition in India, was being followed, is being followed, even in some remote corners of the country today. So Article 17 protects the certain communities and people from untouchability as a practice. Article 18 clearly states that it abolishes all the titles except military and academic. So before independence, India had so many princely states, titles like Maharaja, Raje, Maharaja Adhiraj, very commonly used in front of your first name, right? So these are all abolished. You cannot technically write them down officially in front of your name. But the only two kind of titles that you can still use are your military titles. If you're captain, admiral, or deputy commandant, that is the title you have earned. That is the title that state has given to you. You've earned that title, so you can write that title. Academic title. If you complete a doctorate degree, you can add the term doctor in front of your name. So that's the academic title. Those can be put. So anything that you've earned with your hard work in the military or in the academic field can be used. Anything that is hereditary has to be dropped. Then the next is the right to freedom. Right to freedom are from Article 19 to Article 22. Article 19 clearly states that the protection of six rights concerning the freedom of speech and expression, assembly, association, movement, residence, and profession. Nobody can stop you from saying anything that you're saying unless and until you are respectful towards everyone, not hurting the peace, not hurting the security of the nation. You have the right to assemble. Nobody can stop you from assembling at a particular area unless the assembly is peaceful. Association. Everybody has the right to form unions and associations. Movement. There is absolutely no restriction. As citizens of India, we can move across the states, north, east, south, anywhere, unless and until that area, particular border areas that are restricted for security reasons. Residence. There is no bar on buying houses. You can buy residence in any particular state in the country. You can reside in any particular state in the country. As a Punjabi, I can today start staying in Maharashtra, and that'll be all right. Profession. Nobody can force you into a certain profession just because you belong to a particular family or your hereditary profession was some particular profession. So the barriers have been broken. Everybody has the right to freedom. Article 20 states protection with respect to conviction for offenses. So while you are under the radar of law, while there are some charges on you, even when you have committed some offense or you haven't, or there's some complaint against you, even when you are under suspicion, the Constitution still provides you with certain rights. For example, nobody, and I mean nobody, can force you, not even police, to give a statement against yourself. So there are the rights that you have, even at the time of conviction for offenses. Article 21 is one of the most elaborative rights, right to life and personal liberty. very, very elaborate. We can discuss it in some other class. Over the years, various Supreme Court judgments have led to expansion of this particular article. Your right to livelihood, your right to sleep, your right to good environment, clean water, everything is a part of this particular right. Then we have Article 21A, which is right to elementary education. So basically, right to elementary education means that education up to 8th class is the responsibility of the state, and all the students would be provided free and compulsory education up to that age in class. Article 22 states protection against arrest and detention in certain cases. Then right against exploitation is Article 23 and 24. 23 states that prohibition of trafficking in human beings and forced labor. Nobody can pursue the practice of begari. I hope you understand what begari was, or even for that matter, a very common practice in South India before independence, devdasi, where women were they were donated to certain temples or organizations, and they were forced to stay there for the rest of their lives and serve the deity. So that can also not be done. Any kind of forced labor is prohibited by law. Article 24 states that prohibition of employment of children in the factories it restricts the employment of children in hazardous industries, sets a particular limit, the age limit. Certain laws are made under this particular article. Age limit is set. Below 14 years of age, no child can be forced to work in any hazardous condition. Then right to freedom of religion, Article 25 to 28. Clearly, Article 25 states that we all have the freedom of conscience, profession, practice, and propagation of our religion. Now, that means that if I am a Hindu, I have the right to practice my religion, also propagate, to tell others about my religion. But there has to be a very strong boundary here that I do not push someone to be converted to my religion. Propagation has a boundary drawn that we cannot compel somebody to adopt our religion. That would be against Article 25. Article 26 states that freedom to manage our religious affairs. So all the religious organizations have the right to manage their religious affairs. Article 27 states freedom as to payment of taxes for promotion of any particular religion. So nobody can be forced to pay a tax to promote a certain religion in our country. Article 28 states the attendance at religious instruction or religious worship in certain educational institutions. So, for example, if there is a certain kind of religious prayer being recited in a particular school, for example, there are so many missionary schools, convent schools, they have their own religious prayers, but if some student is not comfortable reciting that prayer, the school cannot force the child to do so. And hence, nobody can be forced to recite a prayer or be a part of an event which that person is not comfortable doing. Then we have the cultural and the educational rights under Article 29 and 30. Article 29 states the protection of interests of minority, and 30 states the right of minority to establish and administer the educational institutions. Right to constitutional remedies. Now, all the above rights that so far we have discussed are rights per se. They tell us what rights do we have in detail, right? But who will protect us if these rights are violated? That itself is also mentioned in the fundamental rights. The Article 32 states that if any of the above rights are violated, then in that case, under Article 32, you have certain writs available and you can approach the Supreme Court directly to protect yourself and your rights. So the Constitution guarantees remedies if the fundamental rights are violated. And these remedies are in forms of 5 writ petitions that you can file: habeas corpus, certiorari, prohibition, mandamus, and quo warranto. Habeas corpus literally means to produce somebody's body. That means that you cannot confine somebody. You cannot arbitrarily hold back somebody physically. In that case, habeas corpus can be used in Supreme Court to free that person. Certiorari and prohibition are two particular writs that are issued to the courts, to the lower courts, when they either violate their jurisdiction in a particular case or they have given a certain order that they should not have given. It's beyond their reach and jurisdiction. Mandamus is to command a particular authority to do their task. Quo warranto is, it literally means with what authority. So if a particular public authority is issuing certain orders or is imposing certain restrictions or certain policies on the citizens, then the citizens, and if the citizens think that that particular law is arbitrary, that particular policy that is being executed is not right, it's beyond the jurisdiction of that public authority, you can file a quo warranto writ petition in the Supreme Court. You can file a writ petition, and the quo warranto is the courts can ask that particular public authority that with what authority are you imposing such restrictions or policies on the people. So we can question the executive powers as well. Article 32 is considered to be the basic structure of the Constitution. That means it cannot be amended. Even the fundamental rights can be amended, but within the fundamental rights, the essence of fundamental right is enshrined in Article 32, because if 32 is changed, that means if our rights to approaching the courts are changed, then in that case, that would be a very big problem, and the entire fundamental right as a concept would be eroded. So 32 can never be changed. It is the fundamental, it is the basic structure of the Constitution. It's the heart and soul of Constitution, as Ambedkar said. Now, Article 15, 16, 19, 29, and 30. Only these 5 rights, and you'll have to learn this, and you'll learn this with time when we'll keep repeating these topics and we'll have regular revision tests. These are the 5 rights that are available only to the citizens of India and not to the foreigner. Okay, that means that foreigners cannot make unions out here in India. They are restricted to move around in the country. They are restricted to pursue certain professions. For example, foreign lawyers are not allowed very easily in the legal space in this country. They cannot come and practice and plead. Now, abolition and evolution of fundamental rights. So over years, there have been certain court cases. There has been a series of judgments by Supreme Court that has expanded the scope of fundamental rights and have also restricted the parliament from taking away or amending these fundamental rights. This itself is a very long discussion, and we can have it in another class, but these are extremely important cases that I need to highlight. A.K. Gopalan case versus the state of Maharashtra, and the other was the Shankari Prasad case versus the Union of India, then the Golaknath case versus the state of Punjab. Keshwananda Bharti case, this particular case would be repeated multiple times in the coming chapters. One of the foundational judgment which shaped how Indian Constitution is protected and how the government functions and how the parliament's power was curtailed when it comes to fundamental rights and the basic structure of Constitution. Menka Gandhi versus the Union of India case. So all these cases, basically what they did was that with each case, the court kept defining how much power does Parliament have to take away the fundamental rights, and what fundamental rights can be taken away, how much, and to what extent, and which ones are sacrosanct and can never be taken away. For example, the fundamental rights and the emergency provisions. Now, I hope everybody knows what is the national emergency. So when there is a complete breakdown in the machinery or in civil administration, it can be some violent event in the country, it can be some uncertainty that is prevailing in the country, and there is threat to the peace, national unity of the country. At that particular point of time, the government declares a national emergency. And under national emergency, a lot of rights that we have are taken away, and the administration becomes very centralized. The state governments, they lose their power. The central government, the prime minister, very strongly knit cabinet decides most of the policies and executes them. So in national emergency, earlier, all our rights would be taken away. So when the national emergency was imposed under Indira Gandhi, all our rights could be taken away. And that became a very, very alarming precedent for us. So eventually, what happened was that the subsequent governments that came, they made certain amendments to the constitution, and they describe, and then certain rights, for example, Article 20 and 21, were considered to be now non-suspendable. That means if today national emergency is declared, nobody can take away your right to life, and Article 20 that stays the right that gives you certain rights under conviction for offenses. So Article 358 and 359 are two articles that discuss national emergencies' effects on our fundamental rights in the Constitution. So Article 358 clearly states that as soon as the emergency is declared on the grounds of either war or external aggression, that means some foreign threat to the country or the country is at war with some foreign power. In that case, when the emergency is declared, Article 19, all the six right to movement, right to speech, right to assemble are suspended. They are completely suspended until the national emergency is there. Now, the only ground on which Article 19 cannot be suspended is if the reason for declaring national emergency is internal. Okay, so if there is a protest in the country, that is not grounds enough to suspend our Article 19, our freedoms. Article 359 clearly states that President can suspend all the fundamental rights under national emergency, but still Article 20 and 21 would prevail and nobody can take these rights from us. Now, I hope that I have given you an overview of what fundamental rights are, how they have evolved over time, how I've given you a brief connect of how Supreme Court judgments have shaped them over time. This was a brief introduction to the fundamental rights. Now, every topic will always be supplemented by the previous year questions because our ultimate objective after understanding the concept and learning the facts is to attempt the paper. So I have compiled some very important questions that have been a part of the CUET PG exam in last 3 years. So the first question, let's come to this. The first question states that which of the following court decisions declared right to privacy to be a fundamental right? This was a question which appeared in the CUET PG exam 2025. So the following were the options available, as you can see on your screen. There were various cases mentioned. K.S. Puttaswamy versus Union of India, Joseph Shine versus Union of India, National Legal Service Authority versus Union of India, Suresh Kumar Porshil versus NAS Foundation. The correct answer stands to be option A. So under the Puttaswamy case, the Supreme Court declared that privacy is a very, very important and essential component of one's life. So it is covered now under Article 21, that is your right to life. So right to privacy was considered to be, was declared as a fundamental right by the Supreme Court in its judgment of K.S. Puttaswamy. The second question was, this is from the 2024 paper, which amongst the following is not covered under Article 21 of Indian Constitution? So out of all the 4 options that are available, right to livelihood, right against solitary confinement, right to freedom from noise pollution, and right to active euthanasia. D is the answer. India does not allow active euthanasia. Euthanasia is the right of a person to take his own life medically under medical supervision. To give up his own life is euthanasia. India does not allow that. We don't allow it. So D is the right option. And the answers I'm sharing with you are from the official answer key. So these are verified and checked multiple times. So these are the right answers according to the official answer key. The next question is again from the 2024 paper. We have to chronologically arrange the provisions of the Constitution according to the order of its appearance. That means from Article 14 till Article 32. As and when the rights appear, we have to arrange them in the ascending order. So take a note of all the 4 rights. So first is right to equality of opportunity in the matters of public employment. I hope you remember we've done this, right? This is Article, if you go back, this is Article 16. Protection of life and liberty is Article 21. Then protection against arbitrary arrest, freedom of speech and expression. I leave up to you. Find out the articles. We'll discuss the answer. So the chronological order is A, D, B, and C. We'll check again on the screen. A comes first, right? Equality of opportunity. 16 comes first. Then the next option was D, B, and C. Then comes D, freedom of speech and expression, 19. B, and then C. B is 21, and then comes protection against arbitrary arrest is 22. Okay. Question number 4, going back to the paper of 2023, arrange the following fundamental rights in the order, in the right order. Again, a similar pattern that we saw in the above question. So you see, you also have to understand the patterns of the question. So chronologically arranging is a very common pattern that we are seeing in last 3-4 years. So you have to remember the rights with their article number so that you're able to arrange. In certain papers, there were 2 questions consecutively on arrangement of these fundamental rights. So it's a very important thing. We need to arrange them: right to constitutional remedies, right to life, right to freedom, and right to equality. The correct answer is B, C, B, and A. The last question for today's question bank, this is again from the 2023 paper. Equality of opportunity means everybody is equal before law and equal opportunity to become unequal. Everybody has equal opportunity and everybody has equal talents and skills. Now, this was a tricky question, I agree, because a lot of you would also say that, ma'am, C is also right. Everybody has equal opportunity, and this was even challenged. Finally, that the final answer key that came after all the challenges had B as the option, and equal opportunity to become unequal. I'll explain it a bit. It's not that difficult. It was slightly tricky question. This means that everybody should be given an equal start. That means everybody should be given equal opportunities in the beginning. And that does not mean that tomorrow everybody would land up at the same place by using equal opportunities. All of us have different abilities, different skills, different environment, different thought processes. So even as we give everyone equal opportunity, we do give them right to end up being unequal. Some will excel in certain fields and somebody might not excel in that particular field so much. Somebody is able to make millions of rupees and somebody is making a decent amount of money with the same degrees also, right? So that means that we're giving everyone an equal opportunity, but they have the right to become unequals. They have the right to put in their effort, skills, their thought processes, and end up at different places later. And that is okay. We are not aiming for equality of the end result. That is what it means. Okay. So I think we have now got a bit of an idea of how the previous year questions are. Because the more you read the previous year questions, you will understand how you have to read your notes and your books. You will know what is important, what is the pattern of the questions, what you have to learn, and what is unimportant. And don't worry, this is not going to come to you just today. We are here for you. We are here to help you. And we have a lot of time. And don't worry, we'll sail through this. Thank you so much for attending the class and all the best.